Hello, my name is Meike Wiest. I am a professional guardian and geriatric care manager with an agency called Arosa, and I'm excited to be here today to speak about adult guardianship. And I want to make a disclaimer. I'm not a legal professional. I'm a social worker, so I will speak about guardianship from a perspective of somebody that provides guardianship to people and speak about the things that surprise people when they're faced with guardianship and what guardianship really looks like in day-to-day life. And I want to start by talking about what guardianship is. Sometimes I might speak to a family member and ask if a person has a guardian, and a family member might say they are. And then it turns out that they might be the primary decision maker as far as a caregiver or family support, but not actually a legal guardian. So I want to point out that a guardianship that can also be referred to as a conservatorship in some states is a legal process. It is something that has to go through a court, and a judge actually has to determine whether a person meets the legal definition of guardianship and therefore needs a guardian. Somebody has to file a petition, and then an actual hearing takes place where evidence has to be presented, and it has to be proven beyond reasonable doubt that a person meets the criteria and is deemed incompetent and will then be assigned a guardian. There are different types of guardians or conservators that can be appointed, and I will not go into great detail with the legalese as there are differences from state to state. However, in general, the concept is the same across the nation. There can be a guardian of the person, and a guardian of the person is a surrogate decision maker for all matters surrounding personhood, such as the place that you live, your health care, who you interact with. It can be really all those day-to-day decisions that we make that fall under the responsibility of a guardian of the person. A guardian of the estate is appointed when a person needs help with managing their finances. So a guardian of the estate manages a person's income, assets, properties, cars they might own, really anything that has ownership assigned to it. There's also a general guardian, and a general guardian combines all of the above. It would be somebody that has general decision-making power over matters of the person, as well as over that person's finances. A limited guardianship is awarded if the areas of decision-making are very specific to specific areas. So I will talk about that a little bit more, but sometimes the areas of healthcare or housing may be limited in which the guardian can intercede. And then lastly, an interim guardianship may be put in place if there is an immediate risk for a person, or a person finds themselves in an unexpected medical situation, such as a coma, and quick action is required. So if there's no time for an extensive hearing and research process, but there seems to be indication for the need to act, a judge might appoint an interim guardian. That is usually for a limited timeline, and then after that timeline is up, you go back to court and re-examine whether the need is still there, whether a permanent guardianship is required, or whether the person can have their rights restored, which is what you call it when a person gains their rights back and the guardianship is reversed. I spoke a little bit about the limitation of a guardianship, and this is something that is very important to me as a professional guardian, and that is something that we see in general is a trend in guardianship away from a general determination of incompetence and more toward a more limited guardianship that really targets the areas that a person requires help. And I say that because in general, a guardianship is a very invasive step to take. It is something that has great consequences for a person that is subject to guardianship, and it should really be taken should not be taken lightly. It should really be considered very carefully in how their rights are limited. So we have seen in our practice and in the nation as well a movement to modernize the guardianship system, to update some of the language, such as incompetence as itself. It's just a very negative term that sounds like you're inept or just bad at something, and that people usually do not respond well to. or also the term that describes the person under guardianship, which is ward, which is also just not a term that people usually enjoy being labeled with. So there's a trend toward updating the language, and with that, a trend away from a general determination of incompetence, which is a legal term, and we're moving more toward a capacity determination, which is a clinical perspective on guardianship. So we're looking at different areas of decision-making. The main one that we oftentimes see in our practice and that oftentimes triggers a guardianship is the medical consent capacity. So does a person really understand the need that decisions need to be made? Do they understand the alternatives, options that they have? Do they understand the consequences of their choices? And then do they know how to access and implement those things? So all those are components of capacity that we look at. They may be limited because a person is in a coma, or they may be limited because an individual has a cognitive disability, such as a dementia. It could also be that a person has very chronic mental illness or substance use issues that impact their cognition. And so those are all components of capacity. The same applies to financial capacity. Does a person fully understand their income, their budget? What assets do they have and where are they housed? How do you manage them? Does this person understand what bills they have? What budget they should follow to make their money last? How do they write checks? Do they understand the consequences if they do not pay those bills? So again, those are all determinations of capacity in that area. Testamentary capacity refers to can somebody make a will? And a person under guardianship can in fact make a will if it is determined that they do have the capacity in that moment to understand what they're doing, to understand their choices, and again, to understand the consequences of those choices. The capacity to drive is another determination, as we, oftentimes, especially children of aging parents are concerned about their parents driving, and that might be part of the consideration for a guardianship proceeding. And in North Carolina, a person loses the ability to drive if they are assigned a guardian, unless there is a determination made to have them evaluated by the DMV for an exception. That can differ from state to state, but in general, the ability to drive is impacted by a guardianship. And then also there's a capacity to live independently. Can a person understand and manage all the aspects of living on their own, accessing what they need? Can they keep the house clean? And we are not talking about physical capacity, we're talking about the cognitive capacity. And then also, do they accept help? Or do they not see the need for help, which might also then lead to a guardianship if they're unable to see that they need help in certain areas. So all those are areas of capacity, and a guardianship may be limited to just one or two of these capacity areas, or it might specify to what degree a person can assist with decision-making in those areas. In general, I want to say that capacity is not a black or white determination. It's not an all or nothing assessment that we make. It is something that is ongoing. And every time a surrogate decision maker steps in form of a guardian, you have to determine that specific situation and that specific issue at hand to see what capacity the person has. And that means that capacity can be impacted by the situation, by the context the person is in, and as well as what is their health status at the time, what is the time of day, what is their stress level, are they familiar with the subject at hand or with the situation that they're in. So for example, a person with a dementia maybe have much more capacity in the morning. After they get up, they're well rested, they had breakfast, they're in their home, they're with people that they're familiar with. In that situation, they may have much more capacity that later in the afternoon when they may be sundowning, or they might have a UTI, or they may be in an environment that's new to them. So in that situation, their capacity might be very different. So we really want to consider all those factors every time we make a decision for somebody else. what we see is that oftentimes a person that is placed under a guardianship or their family members are very surprised that the guardianship might not actually deliver what they had hoped and what they had set out when they initiated the guardianship proceedings. One situation that we see often is that a person is now under guardianship because previously they have not been cooperative, not been compliant with their treatment, and have not been taking their medication, which may have landed them in the hospital many times or has just really left concern, and so the family may have pursued, or somebody else may have pursued guardianship for this person for this reason. And clients are oftentimes surprised that we as guardians, we cannot make somebody take their medication. We might be able to consent to medication. We might be able to make sure that they have access to the medication that they need. We might be able to make sure that they understand their medication or encourage them, but if they refuse to take it, we still cannot make them, even if we are the guardian, and that oftentimes can be disheartening. The same is true for the thought that once you have a dementia, you need a guardian, and that is also not true. Oftentimes, individuals retain their cognitive abilities and some level of capacity until a much later stage in their dementia journey. And especially when a dementia is newly diagnosed, it's a great time to then plan and put measures in place so that a guardianship down the road can be prevented. And I'll speak to that a little bit more in a minute. Also, a guardian cannot control an individual's behavior and actions. Oftentimes a person might be awarded a guardian because they have been making bad choices, have been, acting in an unusual manner, and we can again put in treatment plans, see what might be underlying under those behaviors, put measures in place to redirect, but we might not be able to influence the actions of the individual. For example, if I get a call from a memory care facility that my client, Mr. Smith, is exposing himself in the dining room, I might be able to work with the facility on how can we address this, how can we maybe redirect this behavior, why might he be doing this, but in the end we cannot change somebody's behavior. Another example could be we may put in place housing recommendations for a client, but they can walk away from it. So for example, I have clients that are unsheltered and they are homeless, and no matter how many times I've suggested shelter to them, they have chosen to walk away from it. So there are certain freedoms and right to action that people under guardianship maintain. A guardian also cannot keep a person in a locked environment. Again, we sometimes have family members that are very concerned about the safety of a client or a family member, and they think then a guardian might be able to put them in a safe place where they can be in a locked type setting. And unless this person has a dementia diagnosis and behaviors that warrant such an invasive step, many times there is not an option for that, especially if mental illness is a concern or addiction. Locked options are usually not available unless there is some kind of a legal reason for that. And then a big one also, I think the term guardian in itself comes with that notion of the guardian angel swooping in and fixing everything, but we also don't come with a magic wand. So oftentimes families are overwhelmed because there's a lack of resources, a lack of benefits for their loved one, and they're just kind of throwing their hands up and saying, we're turning this over to the state and they will take care of mom. Well, the reality is that we as professional guardians work in the same system with the same limited resources and the same obstacles. And while we might know how to navigate it a little bit better, we also have a limited pool of funds and resources to work with. And so we are not always that guardian angel we wish to be. And then lastly, too, some people avoid filing for guardianship that might be really needed, but they are concerned that they would then necessarily be saddled with that role as guardian, which is also not true. So a private individual, a hospital, adult protective services, an attorney, there are many ways that a petition can be filed, and the person that petitions does not necessarily have to serve in that role as guardian. sometimes a public guardian, such as myself, can become appointed. I want to speak a little bit about the rights that a person may actually lose under guardianship, and we spoke to that a little bit already. But the guardian theoretically can decide where a person might live, whether that is in the community on their own, whether that is a placement in a group home or in an assisted living, even the state or area. So a guardian does have a lot of decision-making. Whether or not the person under guardianship always complies with that, like we talked about, is a different matter. But this is the decision, unless the guardianship is limited, that the guardian can make decisions about. We talked about the type of medical treatment, the providers, the care plan. All those are elements that the guardian has the right to make decisions, again, unless there's a limitation in the order for the guardianship. If there's a financial guardian, then they have complete control over the person's finances, which can be a huge trigger. You know, money is a sensitive, touchy subject, and that is oftentimes something that people placed under guardianship can get very upset about if somebody takes control over their finances. The ward may lose the ability to drive, as we talked about, unless there's an exception made. The person under guardianship may not serve on a jury for jury duty, which some might actually see as a silver lining. But if you're told you can't do something, you might actually even want to do that. And the ward usually cannot purchase or possess firearms, which is a touchy subject in itself because many states don't have a database that collects who has a guardian. And so there's really no way for people that sell firearms to really know this. So that is something that is a bit concerning. And again, there's differences from state to state. And then lastly, somebody under guardianship may not be able to create a new healthcare power of attorney or power of attorney because the guardianship trumps those roles. There are many rights that a person under guardianship does keep, and sometimes, again, that surprises people as well. The main one we already spoke about is that really a person under guardianship should be allowed to make the decisions that they can make, and it needs to be encouraged for them to be as involved and as autonomous as possible under that guardianship. And so that is something that is very important to me as a guardian. A person under guardianship may retain the right to vote, even though there may be some differences in that from state to state. In some states, a person under guardianship may still be able to marry, which surprises many people. Here in North Carolina, that is the case. And an individual under guardianship may also be able to make a will, like we talked about earlier, if they do have that capacity to understand that process. A person has the right to refuse medications, unfortunately. You know, sometimes that can be a really, really difficult place to be. You know that is in their best interest, and you really want to make that decision for them. However, there is really no way to force medication. Even doctors, even most hospitals cannot force medication. There are really very few scenarios where medication can be given under force. And then lastly, it is very important to know that a person under guardianship can go back to the court at any time and file a motion and have their guardianship re-examined and can go back to the court and see if that guardianship can be modified. And the same is true for other people that are interested in their case. So if a guardianship is limited, but then maybe a person with a dementia declines and their capacity decreases, then the whole situation may have to be re-examined in court, and the guardianship may possibly have to be modified, and some of those limitations may have to be taken away. So all that to say, I think it's becoming clear as we talk about all these different aspects, a guardianship is a very invasive step, and it really may remove considerable rights from a person, and it should only be taken as a very last resort. So I always encourage individuals that are considering a guardianship to really think about all the alternatives that are out there and to really examine how a guardianship can be avoided. Not only is it a very difficult process to go through, it can be very traumatic, it can be very difficult on relationships to have to go through this court hearing. It also oftentimes comes with fees involved and filing expectations, so it can be quite a headache. So alternatives to guardianship that I want to mention, absolutely the biggest one of that is the power of attorney. So my soapbox is always that everybody over the age of 18 needs to appoint a power of attorney for their health care as well as for their finances. And in addition, they need to also appoint a successor. And in that consideration, I also consider my clients, my friends, my family, to really think about and have conversations with those people that they're hoping will serve in that capacity to make sure that they are okay with that they are ready to serve in that capacity, and that they're able to do that. We oftentimes see guardianships happen when a poor choice was made for that power of attorney. So right now I'm working with a lady that named her brother as her power of attorney and her brother-in-law as the successor. Well, she now has advanced in her dementia, and her doctor has said that somebody needs to step in. But when we reached out to those brother and brother-in-laws, they had never been consulted about this, and they have no interest to serve in this capacity, so they want nothing to do with it. And so we are now stuck in a position where a guardianship might be necessary. So I say that to say choose wisely. And then if finances are concerned, to avoid a guardianship of the estate, we always encourage people to work with a financial advisor that can help with developing a trust. An elder law attorney can also be a good resource here to make sure that funds are funneled into a trust that is overseen by a trustee, and then a guardianship may not be necessary. If a person only has Social Security benefits, you can apply as a representative payee without having to pursue a guardianship, so that can also be a tool. Especially with younger people that have maybe an intellectual and developmental disability or mental illness, if they are willing to accept help and see that they need help, a supported decision-making plan can be put together with that individual's input so they can be empowered to choose individuals that can support them if they need it. And it really maximizes their input and autonomy. And then lastly also, care managers or person-centered planning can sometimes be very helpful, because oftentimes a person just needs help and not so much the surrogate decision maker. So sometimes we are involved as care managers, and then by the time the matter goes to court to determine if a guardianship is required, we have already been able to stabilize that person and surround them with supports to a degree that they no longer meet the legal criteria for guardianship. So lastly, I want to leave you with some resources. I mentioned that an elder law attorney can be a very helpful person to consult with when you're considering a guardianship. So I'm listing here the National Association for Elder Law Attorney website, and it lists all of the members that have a specialty in the area of working with seniors, and I think that is a great tool. I also mentioned that a care manager can be helpful. And I'm listing here the Aging Life Care Association's website, and it is a website where you can find members all across the nation that are certified care managers, and you can read about their qualifications and see who's available in your area for support. I also mentioned supported decision-making, so wanted to list their National Research Center website, as well as just a website that summarizes general principles of guardianship by the U.S. Department of Justice. So I'm hopeful that these resources will help you with some additional information as you consider guardianship and wrestle whether that is something you want to pursue. And I hope that this information is helpful if you are facing this decision, which can be a difficult one. Glad that I was here to present, and thank you for your attention.